Hello, this is Saurav Wadhwa from Tax Accountant, and today I'd like to cover a video on trust. What is trust and what is the implication of trust into tax system? Now you could be in any part of the world. The principle of the trust law remains the same because these principles are coming from English law, and this is going back to 1600s, 1700s. So the principles are coming long ago, centuries ago, and this is some form or the shape being tweaked many times for the taxation purposes, but the raw principle of the trust remains the same. So today I'll explain what trust is, the key concepts, and how this is taxed and things. So we need to understand that trusts are legal arrangement. It's not a legal entity. Very important. Trust itself is not an entity, it's just an arrangement between the certain parties. This is what we have agreed and this is what we are going to do, right? So trustee, they are the management. So trustee manage the assets on behalf of beneficiary. So you just need to remember these two people, trustee and the beneficiary. Trustee are the gatekeeper and beneficiaries are the owner. And this is governed according to the Trust Act 2019. So this is New Zealand Trust Act 2019. This is how it's governed. So this is originated from English law for asset protection. So the main idea, there was a story that when the soldiers used to go for a fight, they used to say that, look, tell my neighbor, look, if I don't come back, you look after my asset, my children, my wife, and these things like that. So please look after them, and you are the owner of all these assets if I do not come back. So this is how the origination of trust actually came into the idea that my assets are being protected by someone else to look after the beneficiary of those assets if something happens to me. So this is also a living will. In this will, what we are saying that certain things to happen certain way, and I'm taking off from the ownership of those assets. These assets are no longer mine. These assets are yours, but you are not the owner, like the neighbor. So neighbor, you're not the owner. You are the owner just for the benefit of my wife and my kids. If I do not come back, if I come back, I'll take the ownership back, but if I do not, then please take care of them and use these assets to take care of them. This is the idea was behind it. Now over the years, court recognition led to formalization of trust law, because since then there have been some disputes and things, people going to the court, no, I'm the owner, this is the beneficiary, and all those sort of stuff. So slowly, gradually, the trust law, it's like bit by bit, the trust law came into existence. So as we know today, it's coming from centuries. It's not a new thing. It has been there for centuries. It's going to be there. It's not going to disappear. So regardless of many changes are made to trust law, the open registration, change in tax rate, whatever it happens, it has been there for centuries. It will remain. It's not going to go away. Now the key parties, these are the parties in the trust. So settlor. So settlor is someone who creates the trust and transfer the assets. Trustee is someone who legally owns and manages the assets. Beneficiary receives the benefit from the trust, and trust property is any asset held in the trust. So these four things you need to worry about and need to understand about the trust. Now types of trust, don't dig into too complex. Let's simple. Charitable trust. So charitable trust, something that's done for the charity purposes, that's governed under Charities Act 2005. Family trust, discretionary trust, which is a most common trust. So what are the benefits of having a trust? So benefits of having a trust is the asset protection from creditors and tax department. Now integration of wealth transfer, management of assets in capacity, tax planning, which is limited these days, relationship property protection. So these are the benefits. The main benefit, what I think, is the mainly asset protection. So if you get into any problem and your creditors wants to sue you, please pay me this, please pay me that, you can simply say all these assets are not my asset, this is owned by the trust and I got no links to that. You can get away from that. There has been some cases in the past, and my research was on failed finance company. I can name, but let's not dig into people. But there was an owner who had all these properties in the trust, and the court system could not do anything to him, and he got away simply by saying that all these properties are under trust. So trustee duties. So once we set up a trust, so trustee becomes an important person. So there has to be a duty to maintain accurate records. So if you are a trustee, you don't become a trustee for the sake of being trustee. You need to understand what's going on. So you act in good faith, you follow the trust deed, and you act personally and take advice when needed. So always take a professional advice when you're not sure about something. What is the trust deed? So you might have seen a deed. So deed is a legal document between the parties which is defining the trust. It includes settlor, trustees, beneficiary, power and rules. It must be signed, witnessed and dated for it to become a deed. So there has been a lot of cases in the past when it said it's not a trust, it's not a valid trust anymore, but the court have ruled there has to be 3 certainties to create a valid trust. There has to be intention, there has to be a valid intention to create a trust. There has to be a subject matter, so there has to be a property. Remember one thing, when the soldier was going on a war, there was a property. They said, look after my house, and these are, right, the things that I'm giving it to you. And there has to be an object, which means a beneficiary. Look after this on behalf of, my kids. So beneficiary is there, property is there, my house is there, and intention is there if I do not come back. So there has to be these 3 things. If these 3 things are not there, if one of these things are not there, it's not a trust. So how to set up a trust? First of all, determine a purpose. Why are we setting this up? What is the purpose behind it? Draft up a trust deed. Find the trustees, which is the appointment of trustees. Then you transfer the assets, whether your family home, residential properties, any values of the shares, anything that you want to give it, whether in cash or any other form or a shape. So give those assets and maintain records and hold trustee meetings. That's all. This is very simple. This is how you set it up, right? Operating a trust, trustee manages the trust and its assets. Ensure compliance with the Trust Act, perform administrative tasks such as doing the tax returns, doing the meetings and record keeping of those meetings. So the Trust Act 2019 is not defining that it's very complex. They're simplifying it. Just people made it complex. That don't do this, don't do that, it's going up. Trust is losing its charm, we don't need that. That's not correct. It's just, you just got to do certain things in certain way and it should be okay. Now, asset protection using trust, which is a most important thing. So asset no longer personally owned. So once I have given away my house, my rental properties, anything under the trust, it's no longer my assets, it's gone. So can protect against creditors. So you will get the protection against creditors, but there has to be some timing consideration. It's not that I know that someone is going to sue me and I transfer it, so then could be a clawback. No. You knew it's going to come in and you just transfer it. That has to be done long ago, many years ago, so that they can't even come back. So they can't say that you have done that to deceive someone. So that's not the point here. and it is subject to Insolvency Act and Companies Act scrutiny. So whatever the provisions are in Insolvency Act and Companies Act, it will be scrutinized through there. But if something is legal and intention was there, then you may survive from the creditor's risk. So trust can also be used for relationship property. So trust can protect personal property, family home often not protected, court assess intention, contribution and expectation. If there is a family dispute between the couple, generally it's 50-50 split if it's a family home. However, if there are other assets, there has to be, this is a very technical area, there has to be a lot of discussions around before getting into relationship. But once you are in relationship and there is a dispute, generally court will split 50-50. So there has been some case laws around what is sham trust or invalidity risk. So trust without genuine intention, there was no intention for setting up a trust. Remember those three things: intention, beneficiary and the property. Means the intention was not there, so it's not a trust. So settler retaining full control. So even though settler has parted themselves from those assets, but they're still controlling everything, that's a red flag. So must separate settler and trustee role functionality. Even though they could be same person, but their role and functionality has to be different. So they have to define to the authorities that no, this is not the case. I'm no longer a settlor, I'm just acting as a trustee. And gifting and residential care subsidy, this is another area where have been a lot of confusions around. I want to get some subsidy from residential care, how much can I get? Look, this is a very complex area. Ministry of Social Development will scrutinize it into detail if there is any implication, but they have mentioned on their website that 6,000 per year is allowed as a gifting. Excess gifting may impact subsidy eligibility. So common pitfalls into trust could be poor trust administration, and the settlor, even though they have departed, but they have still controlling everything, and you are not independent, you lacking your independence as a trustee, and you have a failure to update and review trust regularly. But as I mentioned before, those things if you follow, then wouldn't be any problem. But if you do not do the administration, do not file the return, do not do the meetings and such, you're not being independent trustee, you are taking a lot of personal benefits from that, then you will be perceived as not acting in good faith. So this is just a summary of everything what we discussed. So trust remains a powerful tool when property is used. You just need to make sure that you're compliant and you remain independent. And whenever you have doubt, seek professional advice when creating or maintaining a trust. If you have any questions, feel free to reach out to us. These are our details. This is our website. This is our phone number, and this is our email address. Hope you liked this video and you learned something about trust today. If you have any question, please feel free to reach out to us. If you like this video, please like this video and subscribe to our channel. Thank you.